Welcome to Liberty Law Talk, part of Liberty Fund's online library of law and liberty. Your host is Liberty Fund Fellow Richard Reinsch. Our website is libertylawtalk.org, where you can subscribe, comment, find other episodes and links relevant to today's conversation. Our email address is mail@libertylawtalk.org. We'd love to hear from you. Today we are talking with Richard Epstein about his new book, Design for Liberty: Private Property, Public Administration, and the Rule of Law. Richard Epstein is the Tisch Professor of Law at New York University. He is the James Parker Hall Distinguished Service Professor Emeritus and Senior Lecturer at the University of Chicago Law School, and he is also a Senior Fellow at the Hoover Institution. His most recent books include The Case Against the Employee Free Choice Act, Antitrust Decrees in Theory and Practice, Why Less is More, and Overdose: How Excessive Government Regulation Stifles Pharmaceutical Innovation. And of course, some of his classic books, Simple Rules for a Complex World and Takings: Private Property and the Power of Eminent Domain. And many of the ideas in those texts will carry over into our discussion today. Richard, welcome. Glad to have you.
It's very nice to be here.
Excellent. Professor Epstein, I wanted to start the discussion by reading a quotation you have in Design for Liberty from Friedrich Hayek, because I think that nicely opens up the rule of law discussion in the book. And here's the quote: "Stripped of all technicalities, the rule of law means that government, in all its actions, is bound by rules, fixed and announced beforehand. Rules which make it possible to foresee, with a fair degree of certainty, how the authority will use its coercive powers in given circumstances, and to plan one's individual affairs on the basis of this knowledge." End quote. Richard, let me just follow up. You suggest that this conception of the rule of law, while adequate, may not fully flesh out what we mean by the rule of law and what we do need. Are there substantive commitments not found in Hayek's writing on the rule of law that we need? And if this is true, how do we ground these substantive commitments for the rule of law?
This is an extremely important quote, because what it does is it shows that the notion of a rule of law, as Hayek conceives of it, which is faithful to the general tradition, isn't necessarily bound up with any kind of substantive commitment. One could have a complicated system of welfare rights, all of which are utterly inconsistent with classical liberalism, and still try to announce general rules that people can understand in terms of the way in which they're supposed to order their lives. The hard question is whether or not, when you start to have a larger administrative state, you can actually make good on this particular commitment, or is the nature of the substantive rights going to do something to unravel the procedural purity that you're trying to get? And one of the major themes of this particular book is this. In Design for Liberty, the argument is that classical liberal conceptions of limited government, private property, and freedom of contract are not necessarily or logically linked to the notion of rule of law. But in practice, it turns out they're the only set of substantive commitments that you could think about which are going to be able to counter the fatal discretion that is associated with the greater adventures of the modern welfare state. And what this does is it goes to the difference between positive and negative rights classically conceived. When you're dealing with a system of negative rights, it has the following kinds of virtues. One is, it turns out, since the rights are relatively simple in their formulation, keep your hands with yourself, don't trespass on the lands of your neighbor. You don't have any of the great problems of knowledge in terms of communicating these laws to the public at large. So it's not like a welfare system where, by definition, all the eligibility criteria and the amounts that you could get and so forth have to be carved to the particular society based upon its own conception of what it can afford in order to supply these kinds of things. That introduces a very large element of discretion. The second thing about the rule of law in connection with private property is that these rights turn out to be highly scalable. What I mean by making the rights scalable is, if you're talking about a society which has 1 million people or a society which has 200 million people, the differences between private property in the one and the private property in the other are too negligible to even worry about. It's very hard to even identify them. Everybody knows you just have to keep your hands to yourself, whether you're dealing with 200 million people or 1 million people. Well, that's okay. But when you start dealing with welfare rights, the larger the society, the scale requirements don't hold anymore. You cannot administer complicated systems of welfare entitlements in large societies the way you do in small societies. The whole thing tends to fall apart, as the system of benefits is very difficult to calibrate to the individual circumstances of various people. And in addition, this goes to the third point, which is related to the way in which these rights are defined. With a system of negative rights, it doesn't really matter how rich or poor the society is. It will always give you the same rights. Non-interference on the one hand, coupled with freedom of contract with your chosen trading partners on the other. The moment you try to put together a system of elaborate positive rights, the wealth of the economy is going to really determine how much you can afford and what you can give. And the political pressures, like we see in the United States and Europe today, are always going to be such that majorities will vote themselves welfare-type rights, which the system itself cannot afford to supply. So this means that you're going to start at the base to have a genuine contraction in the means of performance. That's going to get you higher taxes. Those higher taxes will start to dull the performance even more, so that by the time you're done, you're going to have to be able to relent in order to make the system go. Well, how do you do that? And this is where the rule of law starts to break down. Well, one of the ways in which you can slow down the onslaught is to put people on queues, to make sure that they can only get their rights after they wait a little bit longer than they might otherwise want to do. That's what happens in Canada, oftentimes with respect to their health care rights. You just can't get the MRI, even though your dog in an open market might be able to get the exact same kinds of services. And then after a while, you impose these requirements on various kinds of firms and individuals, and they can't afford to do it. So you're faced with a crisis. And so what happens is you give a waiver. And I've called this in other publications that I've written, government by waiver. You set a series of unattainable standards, and when the standards can't be attained, you could either throw all the firms into bankruptcy or give ad hoc waivers of uncertain duration to some but not all of the players involved.
Which is what the Obama administration is doing with, say, McDonald's. And yeah, right.
Yeah, it's the mini-med plans and so forth. It works like clockwork. That is, what happens is these systems are so heavily balanced and so highly particularistic that the moment the underlying economic assumptions that one has made in order to put them into place fail, then what you discover is that ad hoc adjustments always have to be made, and it's those ad hoc adjustments which eventually lead to the decline of the rule of law. Or to put it in more simple terms, perhaps, classical liberal institutions are much more robust against the vagaries of time and fortune than any modern administrative state.
Let me ask you this question. And also in defending the rule of law, you make the point that natural law defenses and a utilitarian defense must converge. This will strike a lot of readers as an odd or a paradoxical statement. It struck me as an interesting one. Why do they need to converge, and how do they converge? And also I wanted to ask you, what conception of natural law are you operating from?
These are very hard and long questions, but let me sort of start from the beginning. One of the reasons why I think the way I do today is the peculiar form of my legal education, which started in 1964 in Oxford, and the first course I ever studied was Roman law. So I was very impressionable, and I read these texts, and I was always struck by two things about them. One is the absolute precision and exactitude in which they could describe standard private transactions. And secondly, their utter inability to come up with some really powerful justification for the institutions that seem to be so perfectly attuned to the systems that they had. So if you look at Roman law, every time they have a really tough question, like how it is that individuals come to own private property, they always appeal to natural reason. Ratio naturalis is the Latin, and it means the reason of nature. And, well, what do they mean by that? For them, it was probably the following thing. If you look at the world, there's several ways that you can test whether or not its rules are sensible. One of them is whether or not they comport to some standard of reason, which they don't articulate, but which in the end probably means some set of rules which on average advances the aggregate welfare of the society in question. But aggregate welfare turns out to be an extremely slippery type of an arrangement because what it tends to do is to submerge the position of any given individual with respect to society into the sort of larger whole. And libertarians have always been, I think quite rightly, allergic to notions of aggregate utility which somehow or other allow the whole to swamp any individual person who is part of it. So what you need in natural law is a way to get this kind of consequentialist stuff into the system so that the laws actually serve a purpose, so that it's not just a sort of a mysticism that we believe that individuals have a special relationship with their property, which is so sacred that we can't even begin to define it. And that requires that you get a slightly different definition of utilitarianism, which comes out of the economic theory, starting with a man named Pareto around 1900, and then in a very different but interestingly similar form by Calder and Hicks around 1940. And this is a question of how it is that you can sum utilities across individuals. And what you do, in effect, is make the following proposition. Let every individual have his own subjective utilities, her own subjective utilities, and then ask, when you talk about legal arrangements, whether or not when you introduce a particular modification from the previous state of affairs, you can say with some degree of empirical confidence that everybody has been made off, or at least more exactly, nobody has been made less off. And so what you're always trying to do is to figure out how it is that you can talk about these things in terms of the improvements in the lives of the individuals that they govern. So to start with something which is very powerful to libertarians, freedom of contract is one of our dominant institutions. Now, the great attraction to it, when you think about it in these particular terms, is as follows. I enter into a deal with you. You have your own set of preferences, which I may know or may not know, and the same is true of me. I have those which you may or may not understand. You're going to try to understand what my preferences are to some extent, so you could figure out how to engineer a deal that will satisfy me, while at the same time leaving you best off or better off, and I'll do the same thing. And once you get that transaction, what happens is you have a classic improvement. I'm better off, and you're better off if it's a voluntary transaction. And so at that point, we could say that this two-person system is better in aggregate without having to make any comparisons about the gains that you get and the gains that I get from the transaction. That is, the requirement of consent, which derives from the classical law, means that you don't enter into this business unless you're better off. I don't enter into it unless I'm better off. Now, how do you generalize from that? Well, there are two ways in which you can do it. One of them is you could recognize that the moment this wheel of contract starts to work, you keep on wanting to turn it faster and faster. And that means, in effect, if I buy something from you, what I do is I take the thing that I bought, and I now redivide it, use some of it, and resell some of it to somebody else. You take the cash that you got from me, and you use it to acquire other assets that you like. Every one of these transactions satisfies the mutual gain condition. So the faster you turn the crank in a world of voluntary transactions, the greater the overall happiness of the system, which you know without being able to calculate the utilities and the benefits of all persons. If, in fact, everybody is better off by playing in this game than being kept out of it, you can now say in aggregate that there's an improvement without having to submerge any individual into the overall welfare of the whole. So that's the first move. The second move says, well, what about those people who aren't party to the contract? And this, of course, gets a little bit tricky, but as a first approximation, this is the way in which you look at it. You and I have made that particular sale. You regard yourself as better off because you command greater assets. I regard myself as better off for the same reason. And now when we look around to the rest of the world, what we see is other individuals who have greater opportunities for trade by virtue of the fact that we've traded with each other. So that the general externalities that you get are positive externalities. And one has to stress that word because generally speaking, a legal system doesn't try to give you any specific reward to create one of these positive externalities, while it has to use a huge amount of effort under the law of tort to make sure that these contracts don't murder or maim third persons. So negative externalities tends to be the locus of legal action, but as a matter of social theory, these positive externalities are extremely important. And so as you turn the crank, if the system works correctly, not only do you get private gains internal to the transacting parties, but as the opportunities for the rest of the world increases, the outsiders also gain as well. Now, there are complications. Sometimes there'll be a disappointed competitor who will be worse off in virtue of the fact that he didn't get a deal that somebody else wanted. And one of the great mistakes of sort of modern social theory in the progressive era is to say that ruinous competition, in effect, gives the defeated competitor the right to go. But that's wrong. You never want to evaluate the system based upon how a particular transaction does or does not play out. What you want to do is start at the beginning and ask yourself, if we put in a set of institutional arrangements, are we all better off foregoing the ability to stop competitors from succeeding than we are if we could put a veto over them, having to give them the same right to put vetoes over us? So what you do, in effect, is you then develop in every legal system, and the Romans had this, they called this notion damnum absque injuria, which means there is a harm, damn them, absque without, iuria, a legal injury. And the modernists call these things pecuniary externalities, a term which also seems to have no real meaning to anybody. But what it's designed to say is that if there's just a competitive harm, that's the price that you say for getting this pace, to getting this whole system into gear so that people in the long run can benefit from it. And that includes the person who's a disappointed competitor in one transaction, because there's no limitation on the number of times that you can play. You just enter into a transaction with somebody else. So that's the basic conception that one wants to use. And if, in fact, you do this, the older theories of natural law, which have completely aligned with everything that I've said in terms of their belief in contracts, turn out to have a very powerful sort of modern understanding that backs them up. There are exceptions to this rule. The most important one is that which deals with the Antitrust Law. And the reason why it is that we say collusion between rival sellers is, in fact, they're wrong if they have what we call market power. That is, the ability to raise prices as they reduce outputs. What happens there is the externalities are now systematically negative, just as they are if A and B enter into a contract to murder C. So what you do is you now have ability to have freedom of contract coupled with a perfectly principled set of limitations based upon public policy for those kinds of contracts that generate systematically negative externalities. So it turns out, if you put all this stuff together, that the natural law guys can be justified in a utilitarian sense so long as you manage to do that in terms of the Pareto system or the Calder-Hicks system, and you don't try and go to what Kant called aggregate utilities, which mean the death of individuals as a bearer of individual rights.
Yeah, I mean, just a follow-up question, though, but it seems a lot of social democrats would use the Pareto standard to justify the welfare state, most notably John Rawls.
But he's wrong.
But it seems also, let me just ask a follow-up question. It seems also natural law, particularly a classical notion, would posit human flourishing would be the end, which, and we could say, I could call it human flourishing, you could call it the Pareto standard, but yet it does seem human flourishing might be a way to think about this in the sense of not having things stripped from you for other various uses, general uses, because of the way that tends to surround individuals and submerge them beneath some sort of progressive future good. That is to say, your life is about some sort of notion of equality that we're trying to realize in the future. I was thinking that as I was reading your book, and then also contracts and restraint of trade as well. I guess it depends on, again, the natural law that one works from, because it would seem that would equally fall afoul because, again, individuals are being harmed by conduct that's, in a sense, circumscribing their ability to trade. So the natural law wouldn't have a problem with that either.
It didn't. That's why I'm saying that the things become fairly close together. Let's start with the first point about human flourishing. It's a wonderful term. Everybody's in favor of it. The difficulty, of course, is how you secure it for two people simultaneously instead of having the flourishing of one come at the expense of another. And market institutions, left free of these antitrust complications, are better able to do it. So there's no real difficulty between finding a one-to-one correspondence between the use of the world flourishing on the one hand and the use of the world utility improving on the other. One is more jargon-ridden and the other turns out to be more in the humanist tradition, but really I think they're virtually identical in terms of the way in which you organize the particular system. The problem about the Rawlsian framework was not that he had the wrong framework necessarily. In fact, the veil of ignorance technology is very similar to what Adam Smith called when he talked about the independent spectator who would look at a set of arrangements and decide which of these kinds of transactions were appropriate and which of them were not. The question is whether or not when you organize this thing, what you want to do is to put yourself in a human flourishing framework in which you have a maximum position. Maximin. That is the Rawlsian conception that you want to organize all human arrangements such that you make sure that the position of the worst off is the first position to be made better. And that just turns out to be an impossibly strict constraint, one of the ones that in general you don't want to have with respect to a system because it puts too great a hamper with respect to wealth creation, innovation, and improvement. So one of the things that happens is if you could find a way to take, say, a person who's got one and raise him up to two, at the same time somebody else through innovation manages to get himself from 10 to 1,000, that still counts as a Pareto improvement. the egalitarians are willing to sacrifice some portion of the huge gains to one in order to prop up the guy at the bottom a little bit more, and it's always a mug's game, because the moment you start to say that, what happens is the amount of innovation is going to sharply drop. The opportunities for other people to cash in from that are going to drop as well. So if you think about the way in which innovation works, there's always some kind of initial, shall we say, inequity that people are uneasy about. So you develop new computers at the beginning, it's only the rich people who have access to them in their homes. You get some fancy new cancer treatment, it's going to only be the mega millionaires who are going to be able to take advantage of it. But the entrepreneurs who put these things together are well aware of the fact that if they can lower the price, they can expand the size of their market until the point that you have computers that become well nigh ubiquitous and cancer treatments that become much more widely spread, or to put it more accurately, would be much more widely spread if we didn't have the FDA riding herd over the entire situation, so it breaks it up. So the key thing to understand about this, and the Rawlsian system does not understand it, is you don't want to take just a static look at the way in which the world works. You want to understand that through dynamic innovation, the greatest opportunities for sale and improvements lie with your ability to tap into mass markets. Let me put it to you in another way on the question of public health, which is a very sore thing. You can do a study, and what the study will always show you is that no matter what the level of overall wealth in a society, that rich people will on average do somewhat better than poor people, and will have, let us say, mortality rates up to the age of 50, maybe 40% of those that are least well off. These numbers are not too far off, varies from culture to culture and time to time. Well, what happens when you go from 1900 to 2000? Well, the 40% ratio stays exactly constant over this time, but instead of having rates at 60 on the one hand and 24 on the other hand, you're down to 8 and 3, or something of that sort. And so who gets the bulk of the gain? Well, it's people at the bottom end of the distribution always get the largest gain because they have so much more to gain by virtue of the fact that they're so much more exposed in these earlier worlds. So that what happens is, in effect, if you're trying to measure improvements, not in terms of dollars earned and not earned, but in terms of the well-being of citizenry, what you're seeing is an enormous improvement at the bottom end. That's the great achievement of the 20th century. It has nothing to do with wealth. It has to do with the fact that you can improve the quality and longevity of life through a whole variety of arrangements, some of which involve public health, some of which involve medical care, some of which involve the real sharp reductions in the cost of producing food and shelter. And that's what you want to do. So the notion that you want to stress yourself on trying to figure out in one particular period with one particular transaction how you make sure that the little man does well is going to be the real enemy of the little man, because what it does is it takes this very productive long-term processes and gums it all up by a series of government regulations that have short-term redistribution as their objective, but don't seem to understand the longer kind of dynamic pattern. When you go back to Roman law, truth is you don't hear all that much about innovation. There's no intellectual property law to speak of, and that's because, generally speaking, what you got your gains from there was not from technology improvements. You got them through trade, spices from the Far East in exchange for goods that we could produce there. And it was interesting. In the Roman system, it's pretty clear now that the activity levels of commerce were higher in the later Republic than they were in the Empire. There are all sorts of ways that classical scientists can figure out what's going on by counting the number of shipwrecks, for example. And if you look at the sophistication of their law, which in many ways is quite superior to the modern common law, so I'm not talking about this giving them any benefit of ignorance and so forth, what you realize is that the reason they had to develop these rules, usually in a Hayekian sense by hook and by crook and by chance and by conversation, was that they had this huge commercial enterprise that they were supporting, and there's no way that you can run a first-class commercial operation if you're running it on the backs of a third-scale and a third-rate legal operation.
Let me just switch fields here for a minute. I think about, you give significant discussion in the book to the rule of law within the administrative state, that is, the huge government bodies created by Congress, in effect delegating powers to these agencies and delegating the full panoply of government power, of powers. And I want to ask you, is the rule of law uniquely endangered by the administrative state in an inherent sense, or is there a way to hedge against this, to remove, say, the difficulties that prop up or that exist in our administrative law? But if it's in an inherent sense, Is it your position that what's going on with the delegation of these powers is something the Constitution prohibits?
Well, I certainly believe the latter. I think it's important under these circumstances to be very careful in the way in which you deal with and condemn the administrative state. When I first wrote the title of this book, it was Designed for Liberty, Private Property, and the Rule of Law. And then I realized that this is clearly wrong, is that you cannot run a system of the rule of law unless you have a decent system of public administration, and the system of public administration, by definition, requires some degree of administrators. So you don't want to go forward with the illusion that somehow or other you can knock out the middleman, have private property, have the rule of law, and don't have to worry about the public infrastructure that supports it. But what I've indicated to you before was that if you have a private property system, the degrees of discretion you're going to have to confer upon administrators are going to be much less than would otherwise be the case. But one of the things that we clearly know is that unless you're a very hardline libertarian, which I am not, there are such things as antitrust laws. You have to build roads, and you have to move streets, you have to have defense, all sorts of public goods. And the question is, how can you make these things work very well? And the answer is what you try to do is to make the public sphere look as much like the private sphere as possible. So if you're trying to run a system of highways, what you want your system to do is to have lanes down the middle of the road. So if you cross to the left when you should be to the right, it's a violation, and things like that. Because the moment you have bright line rules which tell you what is or is not legal, you then go right back to that Hayek quote that we started the hour with and realize that you could administer it in those terms. So if you want people to take driving tests, you don't want them to be giving bribes. What you want them to be doing is to look at an eye chart to see whether they can see and other things of that particular sort. So there's nothing about public administration as such which necessarily is inconsistent with the rule of law. When you start dealing with positive rights and you start to create rights to health care, housing, and so forth, that's where you start running into trouble for the reasons that I've mentioned before. And let me just give one example of how awkward this situation can get. What you do is you have a government that taxes, and now the government gives back the taxes in various forms of benefits. And so, for example, there's a tension with religious liberty when the Obama administration comes forward and announces that it has a new definition of what it means to talk about the free exercise of religion, and under its new and narrower definition, it turns out that it will only take public tax dollars and turn them over to Catholic institutions if they agree to all but their own members to supply them with, and then you fill it out with, abortion services, contraceptive services, and sterilization services, none of which they believe in. At this point, you can see where the discretion really starts to trench on individual liberties. There are many people, many of whom write for the New York Times, who don't see the trouble because they say it's our money and we can give it out on whatever conditions we see fit. But it isn't their money, it's everybody's money, and it's gotten through coercion. And so the real question is, suppose that you had a population, one-third of which, if there were no taxes on the subject, would refuse to supply these services for abortion, contraception, and sterilization, and two-thirds of whom would. Now, if you take the money in to the government by taxes, you get two-thirds from the one half and one-third from the other half. Can you all of a sudden take that money and devote 100% of it to people who agree with the majority? And I think that's where the real danger of expropriation takes place, because if the administration is correct on this, then those minority people, when you put them through a system of public health care creation, are going to have to forfeit rights that you could never take from them in a world without taxation. So one of the fundamental difficulties of a modern society, and I talk about this in the book under the rather technical name of unconstitutional conditions, is when the government starts to tax people, can it in fact takes those tax proceeds and use them as though they were not generated by the people who paid them, but were somehow or other manna from heaven. So, for example, suppose it turned out that I just have a lot of money. And what I would like to do is to give my money, and I will only give it to institutions that, in effect, refuse to give abortions or refuse to give sterilizations or contraceptives. My money, perfectly within my right. The offset is there's somebody else who rather disagrees with me, and he could run it the other way around. He will only give it to those institutions that will perform those behaviors. So if you've got private individuals, you get competition between donors, and it works out fine. The moment you start getting taxation in a state monopolist, it doesn't work out so well. And over again, what we do is we see as you start to create the administrative state, the conditions that it will impose upon the grants that it gives or the powers that it exercises are often intended to skew wealth from one portion of the population to another. And that's the kind of abuse that you have to be worried about. But let me put it to you in another way, okay? Is that one of the things I talk about in this book at great length is forced exchanges. That is where somebody tells you, you have to give me this in exchange for which I will give you that. All libertarians like myself have to be very uneasy about forced exchanges, but there turns out to be no way in which they can simply get rid of them. So the question then is how you discipline them, and that's why we have the rules requiring just compensation. The moment you have to pay full compensation for the things that you've taken by force from individuals, it's going to exert an influence upon you to slow down the way in which you particularly act. What happens in the modern welfare state is that governments look over their shoulders, heads and backwards, to see if they can get rid of that compensation obligation. And that leads to overaction in the public sphere. And they can do it in all sorts of ways. Let me just mention two of them. One of them is when you actually do take an occupied property, what you do in effect is make sure that you undercompensate the owner for what he has lost. Just recently I filed a brief in a Supreme Court case on behalf of a company called River Center. Its chief developer is a man named Joe Korff. And this guy owned a prime plot of land in New York City, or just south, a couple blocks south of Lincoln Center, and the State Dormitory Authority decides that it wants to take it after he's 10 years under this incredible, elaborate development process in New York to get the site ready for construction. And what the government does is it values the land as vacant and ignores all the additional work put it in there, and that's about a 2 or 3-fold difference in value. What happens, therefore, is if you undercompensate somebody like that, you're going to have people build dormitories on lots which are much better off for other kinds of purposes. And this is going to wreck not only the poor developer, but it's also going to really hurt New York City, because this white elephant that they have a dormitory that they put in the wrong location will generate no city tax revenues, no stores, no jobs, anything like the private unit that they displace. So you never want to relax your compensation standards, because what it does is it leads to the overproduction of useless public buildings instead of rather important private ones. And the second element of which you get is that what we do is when we start to take property, we don't call it property anymore. We call it a mere restriction on its use. So let me just talk about one illustration to show you how crazy it is. Landmark preservation is an important issue. And there are many private organizations that are willing, in effect, to pay money of one form or another in order to create preservation easements over somebody else's property. So the exterior has to remain unchanged. And the moment you call it a preservation easement, it means that it's a property interest and you're going to protect it one way or another. So you can't take it unless you pay for it or get the consent of the owner to have this thing transferred to you. All right, that's what it starts with. The moment the government comes along and imposes an identical restriction, it announces it doesn't have to pay you a dime, because at this point it's a mere regulation and it's not a taking of a preservation easement. That's all double talk as far as I'm concerned. What happens is the government knows full well that if it's going to pay $0 in a voluntary market, it's not going to get many people to chip in with one of these easements. So what it does is it coerces it for zero price. And you know what? They take many too many easements. This results not only in a personal injustice to the party whose property has been taken, but it also results in a waste of public resources, because this particular easement is probably not worth it in terms of the way in which other gains from society's actions could take place through private owners hiring people and developing the property and doing all sorts of other things. So many of these protected buildings turn out their owners abandon them or let the facade go to hell anyhow, and so you're worse off. So you need, in a system, you have to have a place for government coercion. But the test on government coercion should always be, to the extent that human institutions can arrange it, will the party who has been coerced be left better off than he was without the coercion? And if, in fact, you understand how high transactions costs can block cooperative actions, then, in effect, you can identify cases where that's likely to be the case, and then you have to be extremely careful in the way in which the compensation is provided. And this was a theme that I developed, as you mentioned at the top of the show, in my Takings book back in 1985, but it's such an important theme that one sees that it has to be brought up in connection with the rule of law, because if either of these two conditions is not satisfied, if you systematically undercompensate by ignoring elements of value that a private party has created, or if you call regulations on land use something other than property easements or covenants, what you're going to do is have too much government action. The moment you have this free right, there's going to be a question of whether I'm going to condemn your land or condemn somebody else's land, and then you'll get a competition and influence where everybody will start to go to the local authorities and say, hey, condemn that other fellow's land, don't condemn my land. The moment his goes into the public sphere, the value of my land goes up a bit because there's less land available for private development, and the other guy will start to do the same thing. So you never want to give a government discretion based upon its ability to acquire the property of private individuals for a mere fraction of its true market value.
So in effect, you've also introduced neighbor against neighbor in the sense of we become alienated from one another, and that we're able to use the government and use the takings power to inflate the value of our properties. In particular, several cases on landmark preservation, where even dissenting judges have noted this, I think.
Yes, I mean, look, this is, I think, an extremely important point, which is many people who are more liberal than I am believe in deliberative democracy. And it's not for anybody to turn back and say intrinsically that deliberation by bodies is a bad thing. If you're in a school or in a corporation or in a church and you have a board of directors, you better be able to deliberate or you'll never be able to come up with coherent actions. But what happens is the incentive structures under which the deliberations take place determine whether they make sense or don't make sense. So if you have a system in which you have to pay full compensation to people whose property you're going to take, the deliberations will always be, is this property more than the amount of money, worth more to us than the amount of money we as a public have to pay in order to acquire it? And people will actually make an anxious consideration, hey, is this going to be worth it? The moment the eminent domain law says it's not a taking, it's a mere regulation, and you can now take this thing for zero price, the deliberations will take a very different form. Whom should we be able to put to the test and take advantage of? Who's got the political influence? And what you do is you get deliberation, which will now produce all sorts of intense angers and frustration, so you'll kill the civic peace because there's an opportunity. So in New York City, you want to just watch the way in which this goes. Take a look at its rent stabilization laws, where people are allowed to live in apartments at a fraction of their market value, and you can see the intense amount of maneuvering that they have to extend this particular protection so that it covers their children or their grandchildren, and of a landlord to try to make lives miserable for the tenants so they can force them out and reuse the property at market values. You take a city like Chicago where there's no rent control law, there's no culture of landlords hating tenants. Because what happens is these are all voluntary arrangements. People don't have to hold on to property for dear life because they can get a market deal somewhere else which is attractive. And so instead of getting New York City's two-tier situation where some people are in property at a fraction of its value and everybody else has to pay wildly more for their things, you get a much more equitable distribution of property. And when people outgrow large homes, they move to smaller ones. When people in small homes have children, they move to larger ones. Whereas in New York, you're batting down the hatches, and if you're 79 years old and a widow and you have a 3-bedroom apartment that you don't need, you dare not give it up, because if you go into the unregulated market, you'll have to pay 3 times as much to get 1/3 as much as you've already had. It's just a crazy kind of system, and after you hit yourself over the head so much, people start to believe that this is the only way in which sane human beings can do business with one another. If this is what deliberative democracy is, we want no part of it. What you want to do is to have people deliberate over to what to buy, knowing that they're going to have to respect the rights of other individuals by paying them the full worth of the property once they decide to condemn it.
Richard, in Design for Liberty, you introduce a concept, redistribution last. I wanted to talk about your discussion of this because you make an important point that goes unmentioned a lot of the times, and others in thinking about the theoretical case for the welfare state, thinking of Juvenel's book, The Ethics of Redistribution, or even Hayek's writing, and both of those gentlemen are writing about the British welfare state at its inception. And you make this point that the crisscrossing, amount of welfare payments is so great that this notion that redistribution is inherently progressive and leads to an uplift is actually wrong. Actually, what you end up with is a regressive redistribution, which is a point the Congressional Budget Office recently underscored with its report on payments to Social Security and Medicare coming actually from lower income, less wealthy younger people up to their more wealthier grandparents and parents, I guess, I assume. Talk about redistribution last and how that might play into a better understanding of helping those who are unfortunate.
Okay, well, first of all, let me explain what this particular concept is. If you look at the classical liberal system we're talking about and its basic elements, they are all designed to achieve Pareto improvements in the sense that I've talked about. Voluntary transactions that leave at least one person better off and no person worse off than before. Coercive transactions like an eminent domain or taxation would have exactly the same situation. If, in fact, you apply that, growth becomes your premium good, and there will never be any redistribution to poor people in the sense that they will be made better off and somebody else will be made worse off. And I think in the end, if you start with that, what will typically happen is the size of the overall pie will so increase that the position of those at the bottom will become so much better that you will, in effect, reduce the real need for redistribution in its classic sense, where the distribution that you got from the generosity of others was necessary for your survival in a long, cold winter. So what you want to do is to first adopt your particular strategies to see how you could get growth going. And then once you've done that, if there are, as there always will be, some people who are going to be left behind by a combination of being hit by an accident or by lightning or having made disastrous decisions in some kind of business transaction, what can be done to help them? What people clearly understand is that when people are down on their luck, $1 to them or a meal to them means a lot more than it does to somebody who's better off. And the last thing you want to do when you're dealing with income redistribution or wealth redistribution is to deny that fundamental truth that there's diminishing marginal utility to money. But by the same token, you don't want to be so obtuse to think that the only people who understand that are recipients. Most people who have substantial amount of wealth understand this, and certainly in the 19th century, even before there were any income taxes and therefore any income tax deductions, there were huge amounts of charitable work, and they were all around the place today. And what you'd like to do when you're dealing with redistribution is to first think of it through voluntary means. And in fact, if you start to lower the taxes a sufficient amount, you will probably have more excess cash in the hands of people, given their greater wealth, to be able to indulge in that. And then even if that doesn't work and you're now forced to, as it were, go to public means, the problem is if you get this right, going to be much smaller than it is today, where in effect the level of the transfer payments in the United States and in Europe threatens to bring down the entire system as we lengthen the amount of compensation that we give to people during unemployment till it's close to 2 years. What we do in effect is we now have a very large fraction of the population on food stamps of one form or another. So that even in the rich to poor stuff, there's just too much going on because too many opportunities have been deprived. The second point, Richard, is the one that you just made, which is the moment you start allowing redistribution to take place, it is not going to be the case that the people who are at the bottom of the barrel are going to get most of this stuff in terms of the wealth. It's going to be the people who are slightly higher up in the barrel who are going to be able to get it because they've got political influence. They're the ones who know how to get extra Social Security payments by showing that their children have special needs, for example. They're the ones who will be able to manipulate the Medicare system so that the benefit structures remain high to people who have accumulated private wealth at the same time that kids, often from minority cultures, are having to pay Medicare taxes on the first dollar that they earn, wondering why it is when they earn $33,000 a year, they have to subsidize the health care of somebody at 68 who has managed to earn several $1 million and accumulate that over his lifetime. So that the political process means that you never keep the promise. And you could go on. Agricultural subsidies, they're typically a national disgrace. You have large amounts of protections against imports, which allow you to create cartelized high prices in the United States. When I actually looked at this in connection with some work I did on the New Deal, what you could find were articles which indicated every time the agricultural cartels created by Franklin D. Roosevelt and his administration raised prices a notch, somebody in the city managed to suffer from more malnutrition because of the relative unavailability at decent prices of the kinds of commodities that people need to live. So redistribution is something that you can't control. And if you think about it correctly, and you start with the gross stuff, then you focus on rich to poor transactions through voluntary means, and then you use the state to pick up the residue, you're going to do a lot better overall in society than you are today, where our Medicaid monsters and our Medicare monsters have become so overwhelming that it's quite clear that these systems are likely to go belly up within a couple of years unless they are massively supported by payments. But the problem that we have is basically the current administration, and the Republicans are guilty of a lot of this, they've pledged these same tax dollars, which they won't be able to collect anyhow, to running so many different systems, you don't know which it's going to go. They're going to support the agricultural system. They're going to support unemployment payments. They're going to support the very healthy subsidies that you want to have in the healthcare system. They're going to be huge transfers to education. The basic principle that even a welfarist has to understand is that you can only spend the tax dollars that you raise once. And they have to then understand, as seems to be clear if you just look, for example, at the position in Britain today, once those tax rates go up to 40 and 50%, the actual revenues that they raise start to go down. People change the way and they do distributions, they do salaries, they move offshore, they retire more quickly than they might have otherwise done and live off of accumulated wealth. You can't get blood from a stone. And what Adam Smith said, and it's a note worthy of ending on in this conversation, is that the way in which you succeed in the long run is to have a relatively broad tax base with very few gimmicks and a relatively low rate. And indeed, if you run this thing correctly, what happens is as the level of prosperity in society starts to achieve, the number of people who are going to need transfer payments will be reduced. The amount of money that you have to spend on infrastructure through public means will probably decline through technical innovation, and the tax rates continue to go down. And if you keep lowering those tax rates, what you'll then do is produce a burst on the other side. So right now, it's just watching the public debates on this issue. It's like watching the way in which people debate over how best to commit suicide. Do we start to use austerity? Do we start to strengthen union rights on the one hand? Do we give more positive rights to health care through the system? Do we spend lots of money on various kinds of environmental protections that don't make any sense given the low risks that are involved? We have managed to put together a system which is leading us back to the point where all the gains that we made in the previous century are likely to be either eroded or in some cases reversed. If it means anything, the last 3 years have produced a public policy which has seen income standards for the bulk of Americans drop back to the levels that they were in 1996. And that means that the rich are richer? No, the rich are poorer by even more. And the poorer you make them, the less likely it is that there's going to be anything left to run the other kinds of regulatory and redistributive programs. Right now, we've got ourselves into something that looks like it's at the beginning of a death spiral. And unless we could kind of change our views about how we put this system together, we're likely to see a large number of people facing a very long and gray winter.
Which reminds me of another quote from Adam Smith. There's a lot of ruin in a good nation. Richard, thank you for being with us on Liberty Law Talk. I really appreciate it. The book is designed for liberty, private property, public administration, and the rule of law. Thank you. This is your host, Richard Reinsch, and you have been listening to a podcast that can be found at libertylawtalk.org, where you can subscribe, comment, find other episodes, and links relevant to today's conversation. Our email address is mail@libertylawtalk.org.